Hi, my name is Michael Patterson. I'm an assistant district attorney with the Cape and Islands DA's office. I've been a prosecutor since 2008, and I have been the chief of the domestic violence unit since 2016. I'm here today to speak primarily about evidence-based prosecution, what that term or idea means, and how it assists the criminal justice system, law enforcement, and district attorneys' offices, prosecutors, best hold perpetrators of domestic and sexual violence accountable, and simultaneously and most importantly, protecting victims and survivors of sexual and domestic intimate partner violence. So what is the priority in any domestic or sexual violence case? It's always victim safety. Misconception amongst many that I've encountered and those in my office encounter over time believe that we're somehow on some sort of a merit-based system or a commission whereby we get compensated for length of jail sentences or convictions, and that is just simply not the case. Couldn't be further from the truth. I sought the position that I currently hold specifically because it is so important to make those in our community who need assistance to be safer. Accountability of perpetrators is certainly one factor in the consideration of how we make victims safe. But it is not the only consideration. It is not the first consideration. Oftentimes there can be overlap when striving to hold a perpetrator accountable and keeping victims safe. But that is not always the case, and it's certainly not the position of my district attorney's office to prosecute someone if doing so would somehow jeopardize the safety or well-being of any particular victim. But often these two objectives do overlap. In holding perpetrators accountable and making victims safe, we're also striving to break the cycle of domestic violence and sexual violence, preventing future victims. Most of, I would expect the audience for these trainings are familiar, at least somewhat, with ACEs, or adverse childhood experiences. And we know, studies tell us time and time again, that those children who are exposed to intimate partner violence, regardless of the construct of their parents or guardians or their family life, are more likely to be both victims of sexual and domestic violence themselves in the future, and also more likely to be perpetrators of sexual and domestic violence in the future. So inherent in striving to hold any given perpetrator accountable and inherent in making any given survivor victim safe is stemming the spread and continuation of that cycle of violence within any given family or community. So I want to spend a fair amount of time speaking about what the unique issues are that face domestic and sexual violence cases and how law enforcement officers and prosecutors can better equip themselves to deal with those issues in the real world and in court. These are legal issues that I'm sure you've addressed in basic training and are otherwise generally applicable to any case that finds itself in the criminal justice system, but they have unique effects on victims and offenders within SDV cases. First, the cycle of violence, the actual literal nature of the relationship and the dynamic between survivors and perpetrators of intimate partner violence. In the overwhelming majority of criminal cases that a district attorney's office prosecutes or handles, there is at least an arm's length distance between offenders, defendants, and their victims, whether they be property crimes, nonviolent offenses, drug offenses. There's oftentimes not any prior existing relationship between the victims of those offenses and the defendants. That's quite obviously not the case in domestic violence cases. But it's the nature of that relationship, the pre-existing relationship and the dynamic between these two parties, or more than two parties, that continues to affect and weigh on the process as a case works its way through the criminal justice system. Specifically, this cycle of violence, again, this period of tension building, acute violence, and then reconciliation. It's this moment of acute violence after a period, however long it might be, of walking on proverbial eggshells, where the abuser, perpetrator acts out, and there is an actual instance of physical violence. That is oftentimes the only opportunity or occasion when a victim or survivor decides to or is able to and or willing to seek outside help, to engage law enforcement or other members of the community to stop the violence in that moment, to stem the acute violence, to literally make oneself safe in that moment. But what happens after an offender is arrested and begun to be processed through the criminal justice system is that there is a period of reconciliation, which would occur whether or not an offender is charged and brought through the criminal justice system. And that is remorse, or at least expressions of remorse, expressions of apology, efforts to do more around the house, efforts to behave oneself, efforts to suggest or imply that the offender or perpetrator can and will change. And we see this, again, studies show that this is commonplace in relationships that continue despite the existence of psychological, emotional, or physical violence. Victim dependency is also a unique factor that weighs on sexual and domestic violence cases. Again, there's not an arm's length relationship between our victims and our offenders. They are quite often literally dependent on one another for a variety of reasons. Financial dependence, whether they actually commingle finances and share a home, a vehicle, or other property together, or whether in fact there is no commingling of finances, and we find often the case in ongoing instances of sexual and domestic violence in relationships that one person, namely the perpetrator, the offender, has most, if not exclusive, control over finances in the home. And that obviously presents a significant financial or a significant obstacle relative to the continued cooperation of any victim in sexual or domestic violence cases. If the perpetrator is out of the home, whether he's locked up pending trial or not, he may not be inclined to contribute or support financially his significant other or family. And I will speak generally throughout my presentation referring to perpetrators by he and victims and survivors as she. I know that there will be another presenter today who will speak more further and more intelligently and sensitively as to appropriate terminology when referring to victims who might exist within minority communities who are subjected to sexual and domestic violence, in the LGBTQ community in particular. But there are other issues at play as well. Dependency doesn't just need to be financial, of course. It can be psychological. This idea of star-crossed lovers, that no matter what happens between one spouse or one significant other and their better half or worse half, these people often come to believe that they can't exist without their other, whether they're being abused or in a healthy relationship or not. Substance abuse, likewise, is a significant factor. It's often the case that perpetrators and abusers are, because they primarily control finances in the home, that they are the supplier or source of illicit substances when there is a substance abuse disorder present in a particular relationship. Oftentimes these are things that elicit shame, apprehension. People who are drug or substance abuse addicted are often not open with their community, their family, or their friends about those issues. It's something that manifests itself inside the home, something that the perpetrator is aware of, may very well have control over, and may very well use as a threat to expose one's substance abuse issues if they were to report violence in the home to law enforcement. There's also isolation, literal and figurative. It's not uncommon and quite unfortunate that we see routinely that repeat victims of sexual and domestic violence are isolated from their family and friends. They don't talk to their brothers and sisters anymore. They speak to their mother infrequently. Their abusers exhibit control, extraordinary control over their daily activities in their lives. And of course, if a victim is permitted to engage with and have the support of others in their community, they're much less likely to remain in abusive relationships. And whether it's a conscious decision or not, abusers are aware of this, and they act quite concertedly to control their victims and prevent them from having access to resources and others in their community, whether they be family, friends, or community service providers or law enforcement. Immigration status is another significant issue, which Attorney Colin Mickle will speak further on, but it's one that, again, perpetrators of sexual and domestic violence routinely press upon their victims, that regardless of what I might have done to you, if you're to engage with law enforcement, that you're going to be deported. You're not here legally, and if you call the police, well, I'm going to call ICE or I'm going to call immigration. And unfortunately, there is a lack of awareness and understanding within many immigrant communities as to what their rights are. Not being United States citizens, they still have rights. They are still protected by the criminal laws of this country in every state. Again, Attorney Mickle will speak further to so-called U visas and how those can be a mechanism to assist victims of sexual and domestic violence who are not otherwise lawfully in the country to remain here and to remain safe. I want to speak a little bit further and more in depth about legal obstacles that plague sexual and domestic violence cases more so than they do other cases. Start with the marital privilege. Any spouse in the Commonwealth of Massachusetts and elsewhere in the United States have what is commonly referred to as a marital privilege. Generally speaking, a spouse cannot be forced to testify their significant other, despite what the offense is. There is an exception to that. There's an exception for child abuse. A spouse can be compelled to testify against their spouse in instances of abuse of their child or a child. But generally speaking, we're talking about one significant other abusing their partner. In the context of a lawful marriage, the Commonwealth, myself as a prosecutor, is generally powerless to force one spouse to testify against their other. And this is something that's not lost on abusers who are repeat offenders who have been through the criminal justice system before, and it's more importantly not lost on any defense attorney worth his salt who is either retained privately or assigned by a court to represent a defendant charged with sexual or domestic violence. They know that if there is any way for them to, well, let's say, encourage a victim to not cooperate with the Commonwealth and assert his or her marital privilege, oftentimes that can be the end of the prosecution of a case. And that's why I think that's a significant principle to the backdrop of this evidence-based prosecution. How do we, as investigators and prosecutors, prepare ourselves to proceed in a case and prosecute a case, even if we anticipate that a married victim or survivor will exercise his or her marital privilege? Fifth Amendment right, which we generally understand as the right against self-incrimination. We think of someone having a Fifth Amendment right in the context of, I don't want to talk to the police. They think I did something wrong, maybe I did do something wrong, I have a Fifth Amendment right, I'm not going to speak to the police about what I've done. Whereas in the context of sexual and domestic violence cases, the Fifth Amendment provides or presents a rather significant obstacle to the successful prosecution of cases because it is used as a crutch or a tool, again, of defendants who have been through the criminal justice system, have learned a thing or two, or from defense attorneys. And the idea is this: no one can be forced or compelled to testify and provide evidence against themselves. So in the context of any given case, if a potential witness would be likely to give information or statements about the incident that occurred that would also incriminate them, then they can be found to have a so-called Fifth Amendment privilege. A simple example, which I don't mean to take away from the seriousness of today's topic, but imagine an instance or an allegation of domestic violence between two non-married persons, during which each of them was consuming cocaine or some other illegal substance. The altercation might have had absolutely nothing to do about the cocaine, but nonetheless, each individual admits, or we otherwise know, let's assume, that they were using this substance and in possession of it throughout the course of the alleged crime. The defendant, knowing this, knowing his victim to have consumed and been in possession of cocaine, is most certainly going to tell his attorney that, and his or her attorney is most certainly going to tell the court. Because, in fact, any lawyer would be ethically obligated to make the court aware of an instance where they believe a potential witness has a Fifth Amendment privilege. In the context of sexual and domestic violence cases, oftentimes, unfortunately, victims are in an unfortunate sense, yearning for or waiting for an excuse to not have to have their offender, their perpetrator prosecuted. It's a form of protection. In my experience, it's seen as a shield. A victim has reported something to law enforcement during this instance of acute violence after a tension building period. But as soon as that instance of violence is over, we're back to that reconciliation phase. And the victim is seeking ways to make him or herself safe going forward. The reality is that short of homicide cases, every or almost every defendant convicted of sexual or domestic violence will be released. And in the overwhelming majority of cases, their release will be sooner rather than later. And victims are certainly well aware of this. And when a decision needs to be made about whether that victim stands up in a courtroom and proverbially points their finger at their perpetrator or abuser and says, "This is what he or she did to me," it's oftentimes easier, and it might feel in that victim's mind to be a safer decision to find a way out, to be able to allow reconciliation, or at least to be able to save face and say, I wasn't the one pointing my finger at you, I wasn't the one prosecuting you. Basically, please don't take out your additional anger and resentment and rage out on me when you get home or when you get out. It's a self-defense mechanism. And unfortunately, victims, we find, oftentimes seem to acquiesce to a suggestion by a defendant or defense attorney that they do have a Fifth Amendment privilege, even if it's not legitimate. The narcotics example is an easier one. The less easy example, but unfortunately the more common one, is an allegation of initial aggressor. Defense attorney or defendant, rather, by way of his attorney, represents the court. Well, Judge, the victim, Ms. Smith or Ms. Smith, struck my client first, right? And what is not presented to the court, or what the court overlooks, unfortunately, in many instances, is that almost no instance of sexual domestic violence occurs in a vacuum. There is always context to this. And I don't mean to suggest justification or excuse, but there is context. There are other events, communications, things happening in any couple's life or relationship that lead up to the acute instance of violence. It might be constant threats of imminent physical harm. It might be an abuser literally raising his fist over while yelling and screaming at a victim who is, sure enough, been physically abused in the past. I would suggest it's generally pretty reasonable in these instances where a victim defends themselves. Whether they're the first one to make contact with the other or not, self-defense doesn't give you a Fifth Amendment privilege. But in the context of these cases where victims are often looking for a way out and judges don't have as much context as we might wish they did, Fifth Amendment is an obstacle, therefore, that we face in court on a regular basis. Sixth Amendment privilege, the right to confront one's accusers. 20 years or so ago, it used to be the case that law enforcement could respond to an allegation of sexual or domestic violence, take a report from a victim, and then fast forward to trial, that officer would be able to go into court and regurgitate, repeat what had been stated to them initially at the time of the incident by the victim. So even if Ms. Smith or Mrs. Smith decides for any number of reasons that she is not able or willing to cooperate with the Commonwealth because she doesn't believe it's in her best interest, officers used to be able to go in and testify in their place. That's no longer the case. A series of decisions, Crawford, Davis v. Washington, changed that landscape significantly. No longer can officers go into court and regurgitate what a victim said to them. So it is incumbent upon victims and any witness who experienced or witnessed abuse firsthand to be in court and to give testimony as to what they observed. In very, very few exceptions that really aren't worth delving into in our short time together today, can someone present their statements or their evidence without being in court. This notion that witnesses say, well, I already told the officer what happened, or I already wrote a statement on paper about what happened, is almost never going to be a sufficient substitute for in-court testimony. Public misperception relative to both abusers and victims of sexual or domestic violence. It's The jury selection process. For those of you who have never had the pleasure of being selected for jury duty and going through a question and answer phase with a judge, ordinarily I have live audiences for these presentations. I would inquire of the group how many of you have ever been selected for jury service. Moreover, how many of you have ever been seated on a case that alleges sexual or domestic violence. And the audiences which we make these presentations to are often community service providers or otherwise individuals who are engaged in the criminal justice system in some way or have some specialized experience with sexual and domestic intimate partner violence. I can tell you to a very reasonable degree of certainty that you, if you have any of those experiences professionally, are not going to be seated on a jury addressing issues of sexual or domestic violence. Likewise, if you are unfortunate enough to have experienced either personally or by way of close family member or friend domestic violence or sexual violence, you are not going to be seated on a jury which addresses these issues. Quite literally, the standard and required questions that are asked of any juror in a sexual or domestic violence case in the Commonwealth of Massachusetts is, are you, a close family member or friend, a victim of sexual or domestic violence? Have you, a close family member or friend, ever been witness to sexual or domestic violence? Have you ever been accused of sexual or domestic violence? Do you work or contribute financially by way of donations in any way, shape, or form to an organization that supports or assists victims of sexual or domestic violence? If you answer yes to any of those questions, thank you for your time, but we're going to have you back on another jury, on another case, on another day. This is a huge problem. This is a huge obstacle to the successful prosecution of domestic violence cases because we are quite literally, and I don't mean this in a negative sense, we're actually starting with a very ignorant jury. And unfortunately, the criminal justice system is set up to do precisely that. Now, I don't mean to imply that jurors are stupid, but they are generally, by their own admission, ignorant to the intricacies of sexual or domestic violence. So they come into these cases as jurors with oftentimes very incorrect and outdated conceptions, preconceptions about what abusers in domestic violence relationships look like, how victims of sexual or domestic violence are supposed to react. It is perhaps not rational, oftentimes, the way that victims or survivors of sexual domestic violence react to trauma and abuse strikes those who have not been exposed to that issue as irrational. And oftentimes jurors have a hard time accepting or understanding concepts as simple as, well, if he hit you once, why did you not just leave? And of course, it becomes much more intricate and complex than that. And there's also a stigma. There are collateral issues that often accompany sexual and domestic violence cases, particularly in the context of marriage. There are oftentimes probate, custody, court issues, wherein, regardless of how strong the Commonwealth's case might be, a defendant is loath, if ever, to admit to these charges. There is a stigma attached to domestic abuse, as there rightly should be. But this is not analogous to the overwhelming majority of charges in district courts in Massachusetts, which are caused or at least related to substance abuse issues, where persons in today's day and age can more easily and readily acknowledge their problems, their issues, and seek help, because the court system is set up to provide a wealth of services to those individuals who have substance abuse disorders and are willing to seek out assistance. Whether or not there are sufficient resources for survivors of domestic violence or perpetrators of domestic violence, there remains a stigma that in my professional experience is one that is extraordinarily difficult to overcome. I've seen countless defendants stand in front of a courtroom of strangers and a judge and readily admit horrible things that they've done time and time again. But domestic violence perpetrators are unique in that they are more loath and more reluctant than any others, in my experience, sexual and domestic violence offenders, to readily and outwardly admit what they've done. Because there is understandably a shame associated with that. It's not easy for someone, again, nor should it be, to say, yeah, I abused my significant other. I physically beat them. I constantly verbally berate them. I control every one of their daily life activities, and they really have no autonomy. Because that's what these relationships really boil down to at their core, and perpetrators don't want to admit that. There are further unique issues and complexity in sexual and domestic violence cases within the LGBTQ community. I know there's a presenter today who will, again, speak more intelligently on that subject, but I did want to share just some statistics that reflect the prevalence of domestic violence, sexual and domestic violence in these communities. There is unfortunately a lack of substantial research and data on the issue. The 2010 National Intimate Partner and Sexual Violence Survey, which was conducted by the United States Center for Disease Control in 2010, gives us this information using heterosexual women and heterosexual men as a baseline. And I apologize, I know these statistics are perhaps, they deviate from other statistics on sexual or domestic violence that exist, but at least relative to the population of this study, it gives us some numbers to compare. Relative to the reports of experience of intimate partner violence throughout their lifetimes, heterosexual women and heterosexual men report 35% and 29% experiencing intimate partner violence, respectively. When we look at lesbian and bisexual women, those numbers go up dramatically to 44% and 61%. Gay men and bisexual men don't have quite the substantial increase in intimate partner violence experiences, but nonetheless, they generally track higher than heterosexual men. Unfortunately, there's even less information publicly available with respect to how transgender communities are specifically affected by intimate partner violence relative to heterosexual men and women or cisgender individuals. But the few purposive studies that do exist on the subject suggest that transgender individuals experience intimate partner violence through their lifetimes at an increased rate as well, between 31 and 50% over the course of their lives. So why does all this matter? Why is it important to understand the dynamics between offenders and perpetrators of domestic violence and abusers? It matters because we have to approach every single case of domestic or sexual violence as though the victim is not going to cooperate. Unfortunately, as it turns out, that is overwhelmingly or all too often the case. But it's impractical, if not impossible, to make a strategic decision after a victim has become uncooperative, say, well, now we need to go back and now we need to prepare this case as if we need to prosecute it without him or her, because it's too late at that point. Every sexual assault or domestic violence investigation needs to begin with the premise that we need to prosecute this case and we need to be prepared to address this instance of acute violence without the victim's cooperation. That requires comprehensive investigations, high-risk assessments, and evidence-based prosecution in court. So, to the law enforcement officers, you've heard this at the academy, but it's worth repeating. You are establishing evidence not just to get probable cause, not just so you can fill out an application for a criminal complaint, and not just to have a charge issue. You need to be mindful that you are building a case that should be as airtight as possible and that enhances the prosecution's goals of keeping victims safe and holding perpetrators accountable. Corroboration. If you watch in this presentation and take away one thing, I hope it is corroboration, and that everything that a victim of sexual or domestic violence, or even a witness to, reports to law enforcement needs to be corroborated. Make the case more than just a he said, she said. And I use that phrase knowing that it's outdated and it's insensitive, but I use it intentionally because it draws attention to the fact, or it draws attention to the previously mentioned stigmas and misconceptions about what sexual and domestic violence is. It's not just he said versus she said. This epidemic of sexual and domestic violence touches on all communities, regardless of gender or sexual orientation. But it's a phrase that people still relate to. And unfortunately, it's a phrase that these ignorant jurors who have no real world or professional experience with domestic or sexual violence, it's a phrase they're thinking of. It's something that I hear all too often from jurors, particularly grand juries. We have limited opportunity as prosecutors in Massachusetts to get feedback from trial juries. But grand juries ask questions of witnesses, had ample experiences and opportunities, unfortunately, after a witness tells a grand jury about what he or she experienced, how he or she was victimized, or after a police officer explains to a grand jury how a victim was abused or assaulted or otherwise harmed. And then you're left with the grand jury saying, well, do you have any evidence? I've been asked this question, well, do you have any evidence? Back to those of you who've had the pleasure of being on a jury before, you know that answers given in response to questions under oath are in fact evidence. If I tell you that an hour ago I was outside and I was standing next to the lamppost and a white truck drove by, you can accept, if you believe me, you find me to be a credible person, that a white truck drove by the lamppost at the corner about an hour ago. Me telling you that is evidence of that. But jurors, and I don't know if this is a product of the CSI age, technology, or just unrealistic expectations as to what the criminal justice system does or what evidence should exist in any given case, but people oftentimes are reluctant to accept that a person's word is and can be sufficient evidence in a case. Everyone wants to see physical evidence. They want to see photographs, they want to see tangible objects, they want recordings, they want confessions signed in blood, frankly, but corroborate anything you can about what a victim reports. Independent evidence can assist you in proving a crime without victim cooperation. It can also help you eliminate potential defenses. I don't want to spend a great deal of time on report writing because law enforcement, anyone who's going to be seeing this presentation, has already received basic training on report writing. I do want to highlight and cover a couple things again because I think it's worth repeating in the context of building a case that is viable for evidence-based evidence-based prosecution without a victim's cooperation. Namely, who? First, if there's more than one he or more than one she in your report, please use proper names. No one who's reading a narrative should ever have to guess as to which he, which she, which person, which they is being referred to. But moreover, you have to identify everyone in your report. Going back to the Sixth Amendment right to confrontation, that obstacle in sexual and domestic violence cases, right? We can't have secondhand information presented through a witness. And I'll give some examples in a moment. The next thing, and this is not the who, what, when, where, why, but maybe more important than any of those is how. How does a witness know the information that they are offering to you? Only when you know how a person knows something can you make any effort to corroborate what they're reporting. Is someone telling you something that they've simply been told by another person who's no longer on scene, or did they witness something firsthand, and is there maybe some physical evidence that corroborates that? Secondhand reports, again, lead to additional witnesses that need to be identified. We can't have witnesses regurgitating information in court on behalf of others. Interviewing DV victims. I know Abby Foley touched upon being trauma-informed. I've linked here, hopefully successfully through the PowerPoint, to a PDF from the International Association of Chiefs of Police. I think it provides, it's called the Successful Trauma-Informed Victim Interviewing, and it provides a wonderful, in my mind, template of how to go about interviewing victims of sexual or domestic violence using a trauma-informed approach. Generally speaking, we want to stay away from why questions, and we want to stay away from questions that request a victim to report something chronologically. We know, based upon studies in science, that the brain, or a person when subjected to a traumatic incident, the brain doesn't necessarily categorize information in a chronological, rational order. And in turn, they're not necessarily able to retrieve and report that information in a coherent, logical, chronological order to law enforcement. So it's imperative that we approach victims of sexual or domestic violence with a sensitivity, not only because it helps you get better information from a person making these reports, but in my opinion, moreover, it establishes a rapport with this victim that is imperative to the successful long-term prosecution of sexual or domestic violence cases. When we think about those cases where the victim is going to remain cooperative, potentially over the long haul. In Superior Court, it's not uncommon that cases take years to bring to fruition. One of the single most important things that a law enforcement officer can do at the very outset to increase the likelihood that that victim is going to remain cooperative is to establish a positive relationship, establish and convey that you're there to help this person, that you're concerned about what they've experienced and what they've been subjected to, and that you can empathize. Rapport is an enormous thing in keeping victims cooperative. Whether a victim has been exposed to the criminal justice system before or not, whether they have been a victim of charged offenses or not, the criminal justice process is an overwhelming one, one that undoubtedly contributes and exacerbates whatever stressors, whatever anxiety already exists in the life of that survivor. And frankly, it's quite likely that the criminal justice process is not the most important to that person at that time. Making themselves literally, physically safe, making sure that their children or their family is financially taken care of, and they're able to get by through the day-to-day if their abuser's not in the picture anymore. And the criminal justice process, the court process, oftentimes takes a second seat to that. But if these victims know from the outset that law enforcement and the DA's office and everyone in this system are working on their behalf, to develop a trust, in my experience, goes an enormous way to keeping victims cooperative for the long haul. Thorough physical examinations. We're being trained more and more. Law enforcement officers now, since 2014, are being trained on threat assessments, even more recently strangulation assessment forms. Officers are being trained on to look for particular physical injuries. Petechiae is one of those words. I'd ask the room to show of hands how many people know what that is. And over the last several years, the hands are going up more and more. But these are not things. Petechiae are unlikely to be an injury or symptom of an injury that a victim is going to be familiar with, or moreover, even able to observe on themselves, right? These burst capillaries or blood vessels in their eyes or in an area above where they were strangled or where there was deprivation of oxygen to their brain, in their hairline, their face. They may not even see these. They may not manifest themselves immediately, but it's important to look for these types of things during an initial assessment. Always encourage EMT assessment for that reason as well. EMTs, medical professionals, make great witnesses at trial. Not that officers aren't credible, not that an officer can't say, hey, I observed a black eye, but when you have an independent medical professional who's not involved in the investigation of the criminal offense or charging the defendant, that's corroboration, right? That's what we're striving towards. And lastly, with respect to interviewing domestic violence, sexual assault victims, threat assessment. This is imperative that these forms are utilized and implemented in every instance of domestic assault. The first call for help, we know time and time again, studies show us that the first time that a victim or survivor of domestic sexual assault calls law enforcement, right, during that acute instance, that's not the first time. It's likely far from it. I'd like to tell stories about cases, a recent case where a gentleman had been released from state prison for, not surprisingly, abusing his wife, is released. He finds a new victim, a new woman who he cohabitates with for a short period of time. And the neighbors in a multi-unit complex call police on a particular evening, and the police respond. The police literally interrupt the perpetrator strangling the victim and throwing her through the threshold of a door in the house. She reports, seemingly truthfully, the entire series of events from that evening. She doesn't hold anything back. She's quite candid about the serious extent of the abuse she suffered that night, but she says that was unlike him, that nothing like that had ever happened before, and she portrays this notion to the police that she was shocked at what had happened. Well, unfortunately, in listening to the 911 call, after I got it some time later, I find that the neighbor was not quite as sensitive as I would have hoped to the noises and struggle she heard coming from the adjacent apartment, because in her words, this was a nightly occurrence. She tells the police, they're at it again. And again, she wasn't quite sensitive to what was actually going on in the home because she maybe didn't know. But it was quite clear that the individuals fought and are banging the walls and screaming at each other on a nightly basis. We know that when someone calls for help in an instance of domestic violence, it is not the first time. It is more likely than not the first time that they've been abused. Identifying witnesses is not just the victim and defendant that matter, right? This is corroboration. If the neighbor calls 911, they tell the dispatcher, yeah, you know, I'm sick of this. This is going on and on and on and on again. They're screaming, somebody needs to come. Well, that might very well be the end of that 911 call. It's imperative that after you, as the investigating law enforcement officer, speak to the victim, speak to anyone who was on scene and witnessed something firsthand, you follow up. You follow up, right? The dispatcher's job, the 911 operator's job, is to get necessary assistance to a victim as quickly as possible, whether that's fire, medical, or rescue. Their job is not quite to interrogate witnesses and ascertain what other information they might have that might be relevant to the situation. So it's imperative that you follow up and you do that. If someone lives in a multi-unit complex, whether or not a neighbor is the calling party, as I just said in that example a moment ago, it's more likely than not that this isn't the first instance of abuse, and neighbors are going to have something to add, even if it's not with respect to the incident that occurred that brought police to the residence on that occasion. They might have context for prior offenses or prior instances that could support a prosecution of this case. Names are important. Again, we can't have anonymous witnesses, and I have a report example that we'll get to in a moment to address that further. Witnesses should be separated, if at all possible, when they're spoken to, so that you have no misunderstanding as to what each and every individual person knows or saw firsthand. We can't have group talk, instances where, and again, these are derived from real cases that I've handled, where police are called to a residence by a teenage child of a particular woman who's been abused by her husband for years and years and years. And it is always and only the children who would call for her to be protected. She would never call police for herself. She had a very substantial substance abuse issue with alcohol, as did her husband. But on this particular occasion, the one that ultimately landed her husband in prison, 3 children accompanied the child that the mother called. So there are 4 teenage children in the home. They call police and they report in summary fashion, he's got a knife, he threatened us to kill us, he's beating her, he fled out the back of the house in the middle of January in his boxers. Police arrive, they speak to these 4 kids collectively, and that's the story that they're given. We fast forward to trial, and we're leaving out a whole bunch of details, of course, but fast forward to trial and witness preparation, myself and the investigating officer ascertained that, well, in fact, only one of these children actually witnessed any of what was just explained. Only one of the children was actually threatened to be harmed by the individual. Only one of them actually saw the knife. Maybe a second one said they saw something in his hand. And these are important things, because if we don't properly identify witnesses, independent witnesses, who maybe will remain cooperative or who the Commonwealth can force to testify, right, because they don't have a marital privilege or a Fifth Amendment privilege, it's imperative that we know what each and every one of those witnesses know so that we can properly prepare for trial. Use exact words and quotation marks when possible. Again, your report is going to be perhaps the only thing you have to refresh your memory at some point down the road as to what evidence you gathered and what was determined at the outset of an investigation. Always, 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 always interview the suspect. It does not matter whether they tell you to go pound sand. That doesn't negatively affect the case, but whether they tell you something that is true and thereby corroborate what the victim says, or whether they lie through their teeth, I assure you, more often than not, that will be helpful in your case. The ability to corroborate what the injuries that you see on a victim, for example, can be sufficient to prosecute a case. Imagine a hypothetical where you arrive and a victim reports to you that she was physically struck, she was punched in the face, and that you see a black eye. Or she says, maybe a cleaner example or an easier example, she was strangled. She says that he put his hands in my throat and he pressed and he squeezed until I couldn't breathe anymore. I didn't lose consciousness, but he squeezed really hard, and you see finger impressions on her throat, right? Well, now whether the defendant tells you, yeah, we had an argument, I touched her, but I didn't strangle her. Well, that seems like an easy one to get to the bottom of, right? He's lying. And just imagine how that that would play with the jury. Or, alternatively, he tells you, I never put my hands on her. I never touched her at all. I don't know what she's talking about. Similarly, the weight and effect of his statements are significantly helpful to the prosecution because we can show that he's being dishonest. If we can show that this woman, or if a victim reports A, B, and C, but we don't have anything that corroborates what she's reporting, whereas we can provide evidence that disproves the defendant's version, that can be equally powerful and compelling. Often jurors only need a scintilla of evidence in addition to what a person says to find sufficient corroboration. Why should I believe her and not him, or him and him, or her and her? So these partial admissions that can make or break a case. Again, just hypotheticals. The 911 caller is the neighbor, and she says, I hear loud banging and screaming. You respond, and a victim, whether or not they're ever cooperative, whether or not a victim ever reports what had happened, if the defendant says, yeah, we got into an argument, and it got physical, without describing what physical means, and you have a neighbor, someone who didn't physically see anything but heard, says, well, I heard her scream, get off of me, or I heard a female scream, stop touching me, and then I heard a loud thud. I could see the painting on my wall shake. Someone was clearly thrown into that wall, and immediately after that thud and that painting shook, I heard a female voice scream, ow, you're hurting me. That case becomes prosecutable, whether or not that victim wants to cooperate. Now, I'm not promising you that that case will be prosecuted. Frankly, I think oftentimes the impetus is on prosecutors to be more aggressive in prosecuting these types of cases and less on law enforcement to obtain this information. But you can assist us by making our jobs easier and obtaining this information. That hypothetical, the neighbor, the wall, the screaming, that's most likely a prosecutable case, even without the victim testifying. You only need a scintilla of corroboration, some corroboration to buttress what a defendant tells you. So if a defendant tells you that he put his hands on her, you're looking for anything else in addition to a victim's report that corroborates that he did so. Eliminate self-defenses at the same time. Physical discrepancies between a perpetrator and a victim, size, that matters, document that. Was this 6'5", 270-pound man actually legitimately afraid of his 5'8", 105-pound significant other? Because time and time again, you'll see or hear that 6'5" man say, she was attacking me, she was out of control, I just was defending myself. Well, how much effort does it take for that man to defend himself against that victim, right? Does he have injuries on himself that are consistent with being scratched, that are self-defense wounds? Does he have actual bruises on his face that corroborate his suggestion that he was being punched? Most likely not, but document that and note that. Observations of the suspect. If it's January and snowing outside, below freezing, and you find your suspect in the woods in his boxer shorts and a sleeveless shirt, that's relevant information, especially when the 4 kids inside the house and the wife tell you that there'd just been an assault and he ran out the back door when he heard that we had called police, right? That's called consciousness of guilt. Whether that defendant tells you anything or not, you're going to get to speak at trial about where he was, what the conditions were, and what he was doing when you arrived. The defendant is never obligated to present any evidence in his own defense, but we are permitted to use whatever evidence we have against him to our advantage. So you're going to be able to talk about his consciousness of guilt. Why is he running if he didn't do anything wrong? Photograph injuries that don't match the defendant's story. One other thing I want to focus on for a minute, phones. Phones are quite possibly your single greatest source of corroborative evidence, right? Phones have everything that people do on them now. Text messages, phone calls, emails. Victims more and more, I'm finding in my experience, are self-documenting. Either pictures of physical injuries or abusive conversations, threatening messages, constant harassment, whether the messages are threatening or not, just the volume, incessant nature of messages. Victims aren't necessarily taking all this information immediately and giving it to law enforcement and saying, hey, look, this is what just happened right now. But we're finding more and more that victims are saving this information so that when they finally do reach the precipice of reporting, when they finally do find themselves in that one moment of acute violence where they realize, I can't do this anymore, I'm not safe, I need help, then they have this treasure trove of evidence of past abuse, which is a gold mine. Oftentimes, it will not corroborate the incident for which you have been, dispatched and that you're called out to, but it can paint a long picture and history of abuse, which in the context of domestic violence cases can be admissible. I won't do a deep dive on it today because I don't want to get too in the weeds on the law, but generally speaking, the Commonwealth is prohibited from introducing what are called prior bad acts. Easiest example I always give, if someone is charged with operating under the influence of alcohol or so-called DUI, and it's their alleged 10th offense, that jury will never hear about the 9 prior offenses until after, and only if the defendant is convicted of OUI. As human beings, we might think, well, that doesn't make sense. I want to know that this guy's been convicted of OUI 9 times before, right? That seems relevant to me. Well, the law tells us it's not. In the context of domestic violence cases, it is a high hurdle to be able to introduce evidence of prior abuse in a domestic violence relationship, but it is not insurmountable, and it is distinguishable from that OUI example, and that oftentimes it is the case that there is context, relevant context from one incident of abuse to another, or there's a pattern of abuse. There is a particular way in which a perpetrator abuses his victim. And so it's imperative that you collect any evidence you have of abuse or intimidation or control or coercion, whether or not you think in that moment that it's relevant to the incident that you're investigating right now. The victim might tell you, well, I was attacked this morning. You should be asking questions about the nature of the relationship and what, if any, abuse had existed previously. The simplest way, there's all kinds of ways to get information off of phones, right? We can subpoena it, we can write search warrants, we can do all a number of things. The simple, easiest way that most victims are going to be, or that a majority of victims are going to be most comfortable with, can I just see your phone for a minute? I'm going to do it right here in front of you. Or alternatively, do you know how to take screenshots? Would you mind sending these things to me? Victims don't want to give up their phones. No one wants to give up their phone because it's our lifeblood. Everything we have and do and everything that's private to us is in these phones. But you need to make whatever efforts you can in that moment to extract that information, preserve it, because rest assured, after this acute incident of violence is in the rearview mirror long enough and the victim has reached the reconciliation phase, all too often that information is gone, whether it's literally deleted by a victim or whether a victim simply doesn't provide it and is unwilling to provide it to police going forward. It doesn't matter. If you don't get it and strike while the proverbial iron is hot, you often won't get it. Screenshots. And one specific piece of advice on screenshots, if you have a screenshot that says 1, 2, 3, 4, 5, right? These are the 5 messages. I don't want that second screenshot to start with 6, 7, 8, 9, 10. Screenshot 1 is 1, 2, 3, 4, 5. Screenshot 2 is going to be 5, 6, 7, 8, 9. It's imperative that whether we're showing, when we're showing a dialogue, threats, or just contextual communications in court, that the court knows we're not hiding anything, folks. This is the exhaustive entire thing. The worst thing you could do is take selective screenshots of only the messages the victim wants to show you. And understandably, the victim's going to draw your attention to messages that are important. Hey, look, this is the picture of the bruise, and this is him texting me that he apologized. Is there a date stamp present in there? Do we know when it was sent? And do we know what was being communicated before and after? It's imperative that we be transparent and we get all that information. Photographs. Again, photos are enormous corroboration. Bruising varies from person to person, individual to individual, and varies over time. All too often, unfortunately, I know it's with the best of intentions, officers, either themselves or with the assistance of their local sheriff's investigators, they take photographs. And overwhelmingly, these photographs show nothing. Nothing. Maybe they show some slight pink skin color on an otherwise very Caucasian victim, right? Maybe they show some slight swelling that you can see if you're in person. But they very, very rarely show what I talked about before, those clear hematomas, those clear finger marks. Maybe the next day, right? Have you ever run into a table without paying attention, banged your knee, your thigh, thought, oh my gosh, that really, really hurts? But lo and behold, there's nothing there until the next day you wake up and you say, holy moly, who hit me with a baseball bat? That happens. That's common sense. We know this, but sometimes we get tunnel vision and we're taking photographs in the instant of that initial report and we think, all right, we've taken the photographs, we're done. We're not, and we shouldn't be. We should be following up, whether it's through detectives or whether it's through victim service coordinator in a police department or whoever. Friends, family members are going to be the victim themselves if they're willing to provide continual updated photos that show the evolution of bruises. And that's important because it helps to disprove and foreclose the defendant's inevitable version that, well, that was from walking into a door or that was from a fight she had with her girlfriends a week before. If you can show the various stages of the evolution of a bruise, you stand a much better chance of showing when that bruise or that injury was inflicted. There's some reports in the next few slides. I'll go over them very briefly because I'm starting to get towards the end of my time here. This narrative, the first one, officer does a great job of describing that he's with a victim. She shows him an iPhone, or shows him her phone that shows a call from a number that's apparently attributable to Cape Cod Hospital, although I'm assuming that based upon the report. And the officer listens to the message. Sure enough, it's from the husband, and he calls the hospital and says, hey, don't let him call her anymore. There's a restraining order in place. What the officer didn't do was record that message, make a copy of it, or speak to anyone at the hospital about what that phone number, where it came from, what room it came from, or otherwise allow us to connect it to the room that the patient, namely the defendant, was in. This report, just the first couple paragraphs are really relevant. In summary, victim and her perpetrator are at an establishment in town. They're at the bar having some drinks. He, because of an argument that they've apparently been having that's going on, leans into her. She thinks he's going to whisper in her ear, and instead he bites a portion of her ear off. Obviously, or not, maybe not obviously, but after the fact, police are called. Manager of the bar seems to be the point person, whoever was on duty at the time. So police are met by an individual at the door. She says, so upon arrival, met by the owner. Owner directs the officer to the women's bathroom where the victim is. Walking to the bathroom, the owner says a man came into the bar, walked over to the woman, and bit her in the ear. He ran out right after. Was there anyone else in the bar at 6 p.m. on that day? There were numerous people based on my conversations with the owner. Were the names of any of those individuals obtained by the investigating officer? They were not. None. I have a room full of percipient witnesses, none of whom could be identified, and a victim who ultimately cooperated, but had she not, would become a very difficult, if not impossible, case to prosecute. This is a two-part report, 1 and 2. Long story short, 3 separate sets of calls come into 911, all reporting a black male assaulting a white female at various locations, although close together within one town on Cape Cod. The first call, the officers respond. They actually encountered the 2 individuals. They both deny that any physical altercation had occurred. The reporting parties aren't on scene. Dispatch did not obtain their identification. Second call, the officers can't find the individuals. The third call, they arrive at the location. There are 6 men pointing to the woods saying, she's screaming for help in the woods. She needs help badly. The officers leave those 6 men behind, none of whom will be identified at any point. The officers walk into the woods and they actively come upon the defendant standing over a half-dressed victim, beating her, stomping on her back, yelling at her that he's going to do so. The case goes forward to trial. The victim tells the police right then and there that nothing happened. They were having rough sex. She's not going to cooperate. She, not surprisingly, had a pattern of not cooperating with law enforcement. The defendant was found not guilty after trial because the only evidence the Commonwealth had to present were the 2 officers' testimony, one of whom didn't have the same opportunity to observe what the first officer into the woods had. No less than 10 percipient witnesses to this abuse, none of whom were identified. That defendant, a year or 2 later, was successfully prosecuted, convicted, serving a state prison sentence because some gentleman walking his dog on Main Street in the same town stopped walking his dog, called the police, and stood by while this defendant abused his next victim in full view of the entire public, as, again, dozens of others walked by. It's imperative that you identify witnesses, folks. The last, I'm not going to go into the details here. These are two reports on the same subject. The one on the top was written by a relatively young patrol officer. The one on the bottom was written by the on-duty sergeant. I'll leave it to yourself to review those. The first report is fine. It conveys information, but it doesn't establish how, right? The how and the who. How do we know what we're claiming to know? It's imperative that you be able to explain every step of the way, not only what your evidence is, but what your source of that evidence is. The sergeant does an exemplary job of identifying how things are done. Not just, well, the defendant was served with a restraining order, therefore he knew about it. No. I served the restraining order to the defendant in hand. I read to him verbatim what the order said, and he acknowledged that he understood by saying the word yes. Right? That's very different and much more specific than just saying he was served the restraining order. Because 2 years later, officer, how are you going to tell me about how that defendant was served the restraining order? Because I have to prove notice. You just said he was served. How was he served? I'm going to skip over the first complaint doctrine in depth because of time constraints, but I want everyone to be aware of it. My takeaway, for those of you who are not trained sexual assault investigators, pretend to be. Do your best. I don't mean fake it. Don't pretend like you're actually a sexual assault investigator, but don't put up the proverbial earmuffs. Don't cover your eyes. Don't walk away from the situation when a victim tells you, yeah, I have been sexually assaulted, right? Because these threat assessments that you're trained to use and implement now ask specifically, have you ever been forced to engage in sexual activity against your will? It's disheartening. It's overwhelming sometimes. The occasions or the frequency of the occasions with which we hear for the first time that someone's been sexually assaulted because of these pointed questions. But for that officer expressing concern and going through these questionnaires, we wouldn't know this. So it's imperative that you ask enough questions to be able to repeat in court what the victim tells you about their sexual assault. This is one of those exceptions where you can regurgitate secondhand what someone tells you. Within that IACP trauma-informed questionnaire that's attached in the materials, there is a section specifically on sexual assault reporting. And really the crux of first complaint doctrine is why? Why? You're allowed an exception to talk about what a victim tells you about sexual assault because there are misconceptions about reporting of sexual assault. This misunderstanding or belief that if this happens to someone, they're going to report it immediately. We know that's not the case. So you are permitted to provide context. Was their abuser just arrested or otherwise moved out of state and now they feel safe for the first time? Or was a victim told, hey, we're going to go stay at Uncle Johnny's for the weekend, and Uncle Johnny's been abusing this victim for the last 4 summers? She tells mom and dad before going to see Uncle Johnny. It's that context. Why is it being reported now that you would be able to repeat in court? So don't be afraid. You're not a sexual assault investigator. Someone tells you they've been sexually assaulted. You ask, first thing, have you told anyone else? You're not asking that question to save yourself work. You're asking so that you can identify potential additional witnesses. Regardless of what the answer to that question is, regardless of whether or not they claim they've told someone else, you're asking questions sufficient so that you can tell a supervisor what the nature of the sexual assault is and why it was reported now. Because there are exceptions that are not worth getting into in this presentation as to why the real first person told might be excluded from testifying in court and you might be their replacement. Testifying tips, read your reports before you come to court, folks. Please, 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 please. And dealing with defense attorneys, don't take the bait, be respectful. If you're testifying in court, you are the narrator, the director, the producer, you are giving this story to a jury. Don't buy into nasty questions with attorneys. I once had an attorney ask a detective why they didn't fingerprint pills found within a pill bottle with the defendant's name on it in a room that the defendant identified as his. That's a stupid question. The officer handled it with aplomb, right? Quite honestly, sir, we don't have the resources to do that, and it didn't seem necessary based on my experience in investigation. Like, whatever it might be polite, know that the jury's going to think that question is just as stupid as you do. Memory lapses, never guess. If you don't remember something that you know was in your report and you're asked, is your memory exhausted? The answer is always yes, because if you guess and you give the wrong information, you misremember what was in your report, you're stuck with that. A prosecutor cannot impeach their own witness and can't show you your report to make you change your answer. lethality assessments, which is more important. I should have moved it up in my presentation, right? Why do they matter? Why do these forms and these assessments that you're going through prior to the conclusion of any interview with a sexual or domestic violence victim matter? Jacqueline Campbell, who's an expert in the field, studied domestic violence for over 20 years, and her studies show that over 50% of instances of domestic violence-related homicides, or in 50% of domestic violence-related homicides, officers had been called to that home before. This shouldn't come as a surprise, but most domestic violence homicides don't happen out of the blue. 50% of the time, at least it's suggested that there has been prior law enforcement involvement with those victims. However, Dr. Jacqueline Campbell's research also showed that only 4% of those victims had ever availed themselves of domestic violence services. So, making victims aware of services is paramount to getting them involved and engaged with services. And they are much more likely to do so if you, the trained professional, express to them your grave concern based upon the litany of positive answers they give you to these threat assessments, right? Studies show that positive responses to these questions indicate an increased likelihood of lethality. Victims might not know this. They might feel in their hearts, they might feel in their guts, they might know that their abuser can kill them. But to come from a trained professional who has some training and experience and can specifically articulate why they're concerned that a victim is subject to an increased likelihood of lethality can mean quite a bit. Lastly, high-risk task force. Nearly every jurisdiction in the Commonwealth of Massachusetts, to my knowledge, has one. In your materials will be attached the most recent 2019 contact list for every high-risk domestic violence high-risk task force throughout the Commonwealth. Generally speaking, they are comprised of individuals from the district attorney's office, prosecutors, victim witness advocates, police departments, whether they have a specially designated DV, detective or officer, or whether or not they might have a civilian victim service coordinator. The probation department, at least in Barnstable County, the jail, we have a victim services coordinator there, an Independence House, not surprisingly the most important partner in Barnstable County's high-risk task force, but you have community service providers that are parts of yours as well. That information is there. Please contact someone with the team if you are aware of a perpetrator or a victim or both that you believe is subject to an increased likelihood of lethality. These are multi-collaborative agencies, and the fundamental goal is information sharing. If a community service provider or a probation officer or anyone is aware that a particular victim is subjected to an increased likelihood of lethality, everyone else is better served and better able to do their job if they're aware of that information. So please don't hesitate to contact myself or your respective contact person if you have any concerns or questions about particular domestic violence victims or perpetrators. Thank you.